But it was the Attorney-General, George Brandis, attracting the most attention in Parliament today after he declared Australians have a right to be bigots. From Canberra, Jane Norman reports.
A celebration of Australia's migration history. Normally a bipartisan event, tonight Bill Shorten had a very pointed message for the Attorney-General.
No one has a right to bigotry in this country.
Earlier today, George Brandis made his own declaration of free speech.
Well, Mr. President, people do have a right to be bigots, you know. In a free country, people do have rights to say things that other people find offensive or insulting or bigoted.
That offended the opposition.
Why is the Prime Minister weakening decades of protections against racial hate speech? And does the Prime Minister agree with the Attorney-General when he said today in the Senate, and I quote, people do have a right to be bigots?
Of course, this government is determined to try to ensure that Australia remains a free and fair and tolerant society where bigotry and racism has no place.
George Brandis is drafting changes to the Racial Discrimination Act to avoid a repeat of the Andrew Bolt case, where the columnist was found to have broken the law when he wrote about fair-skinned people of Aboriginal descent.
Back to our top story, proposed changes to federal racial discrimination laws. 18C, the particular section which has raised the ire of the Prime Minister and the Attorney-General, was introduced in 1995, making it unlawful to offend, insult, humiliate or intimidate someone on the grounds of their race or ethnicity. Over 19 years, less than 100 cases relying on 18C have actually made it to court. Senator George Brandis says some of those cases have had the effect of stifling and censoring important public discussions. I spoke to the Attorney-General a short time ago. Senator Brandis, good to have you on the show again.
Hello, Emma.
Section 18C of the Racial Discrimination Act has been used by Australian Jewish groups against Holocaust deniers and Nazi sympathisers. Now that you've abolished 18C, where will the Jewish community go to for redress? Or should I say you're considering abolishing 18C?
Well, we are going to abolish Section 18C in its current form. It's a promise we took to the election, and this is a government that keeps its promises, so we will be doing that. But today I released an exposure draft of our thinking. This isn't necessarily the final form. We want to involve the community in this process because it's a particularly important, it's important that we get this right. Now, coming immediately, Emma, to your question, one of the important reforms we propose is to introduce for the first time into the Racial Discrimination Act a prohibition on racial vilification, which is defined as incitement to racial hatred. Now, it's actually quite remarkable that the Racial Discrimination Act has been around since 1975, and yet there's never been a prohibition in it against racial vilification. There is in most of the state and territory acts that cover this field, but not in the Commonwealth Act. So that's a lacuna that we are going to address.
Why have you chosen such a narrow definition of vilification, to incite hatred against a person or persons, as opposed to the dictionary definition, which is abusively disparaging speech or writing?
Because we think inciting hatred is the core concept of vilification, and that's the way it's defined in at least some of the state acts. There is also a body of jurisprudence about racial vilification, and there's no doubt that the core concept is the incitement of hatred. And as well, I mean, let's be frank, the other thing we wanted to do with these reforms is to ensure that the expression of legitimate opinion was not penalised, and as we saw infamously in the Andrew Bolt case 3 years ago. So, you know, whenever one is dealing with prohibitions on what people are at liberty to say in a free country, in our view, those prohibitions ought to be drawn narrowly rather than widely.
And we'll go to the Bolt case specifically shortly, but just to stay with the issue of the Jewish community, Colin Rubenstein of the Australian Israel Jewish Affairs Council says your changes go too far and that he's disappointed.
Well, Mr. Rubenstein, Dr. Rubenstein, who's a friend of mine, was one of the people, one of the many members of the Jewish community with whom I had discussions during the quite long consultation period I undertook. And I understand that the Jewish community, for, in a sense, obvious reasons, have particular sensitivities about this. I actually think that the protection against vilification, which we are introducing into the Act, is more serviceable and useful to them than the provisions that we are omitting, which plainly had a prohibitory or indeed, or at least a chill effect on public discussion.
Now, you've used the legal action against columnist Andrew Bolt to justify changes to the Racial Discrimination Act. What was wrong with Justice Bromberg's ruling in that case?
Well, I'm not saying that Mr. Justice Bromberg's ruling was legally wrong. Some have said that, by the way, but I'm not necessarily saying that to you. But where the ruling in the Bolt case took the Act was to establish that a person who was making a comment on a matter of public policy could, merely because he offended or insulted members of a defined racial group, be effectively censored from making that comment, required to apologise, and at pain of being in contempt of court, prohibited from repeating that comment. Now, I don't think that that is, if that's what Section 18C meant, if that was its reach or its ambit, as Justice Bromberg decided that it was, then I don't think there is a role for that in a free society, just as I don't think that political censorship or the prohibition of the expression of opinion is the way to deal with a problem as delicate as racism.
Okay, for the benefit of those who aren't familiar with the case we're referring to, Andrew Bolt wrote 2 columns published in Melbourne's Herald Sun, the country's biggest-selling newspaper. The articles implied that light-skinned people who identified as Aboriginal did so for personal gain. The judge found that Mr. Bolt had made at least 19 errors of fact and 1 gross error of fact. Further, he said Mr. Bolt had distorted the truth and made comment unsupported by any factual basis. Is that really the kind of public discussion you want to protect?
Well, I think, Emma, frankly, whether Mr. Bolt made errors of fact is not the point. I mean, people make errors of fact in discussion and argument about public issues all the time. Not a day goes by in this Parliament in which the most outrageous misrepresentations are made. But you don't pass a law that says a person can be prohibited from expressing an opinion because they might have made a mistake in developing their argument.